Добрый день, уважаемые коллеги.
Good afternoon, distinguished colleagues, distinguished participants of the forum. And now we start our roundtable dedicated to trans-border cooperation in the field of environmental protection. I would like to welcome all the guests of our city, and I'm really happy that you came here at this time, which is so beautiful in St. Petersburg. And I hope, well, as the moderator of the round table, I would like to make a short, cut why we decided to call this round table this way. If you remember 5 fora, the environmental roundtable was only last year at the 4th legal forum. And as practitioners of the water works, we invited the guru in this field, in the field environmental protection. We decided to give to our speakers to choose their own subjects to discuss. And finally, we decided to call it last year Water, the Legacy of the Past, Resource of the Present, Right for the Future. And it so happened that we have the topic to discuss, trans-border cooperation in the field of water resources, trans-border water sites. And this year we had several fora, several conferences dedicated to this issue, just in the framework of the forum at the university. Environmental department just conducted one of the events. And that's why today we decided to concentrate on this very issue, especially because trans-border cooperation is gaining real significance, especially when water resources of national jurisdiction could affect the quality of the water site of another national jurisdiction. I provide this example. 2005, when there was an accident in one of Chinese enterprises, which could lead to a number of towns on Amur River, so it could deprive them of potable water. And we could also provide a very good example of St. Petersburg. We don't have any alternative source of fresh water, only Neva River. And Neva River is flowing from Ladoga Lake. And Ladoga Lake gets the water from Russia. It's 10%. The rest of Ladoga Lake water is coming from Voksa River, which starts in the lake system of Finland. We are really lucky because international lawmaking of Finland is more than 500 years. And since 1964, the Soviet Union and Finland had the agreement on trans-border water sites. And in the course of all this time, talking about our enterprise, why we decided to be in charge of this issue. More than 10 years ago, using the joint effort of the number of countries on Baltic Sea in St. Petersburg, we built south-west water clearing filters. And well, you can see the slide, and it's quite evident. Up to 15 foreign companies that you can see, they provided the loans, they provided the grants. And the result of this work was clearing just the wastewaters, and then we managed to clean Baltic Sea. We paid back our loans, And this is one of highly successful projects. That's one of very successful examples of trans-border relationship between different countries. Well, speaking about international legal acts, well, here we're going to give the floor to the representative of our ministry. But I believe that I'm going to dwell on the following. This year, in April 2015, we had the 7th Water Forum, which discussed the problems and issues of water and what is significant. They looked at all the elements of managing water resources, rates and tariffs, information, water, quality of water, and then the final decision of this forum is going to lay the foundation for the forum in 2015 in New York City in the United Nations. But when we start talking about trans-border water sites, I would mention Helsinki Rules of 1966. And the idea is not to harm the territory of another country as the result of harmful human activities. It must be fair use of water by every state in the region. And also 1992 is another year. That's when Dublin Principles got established. Also Helsinki Convention that actually defined the notion of transborder water sites, transborder influence, then the polluting party is paying. Then the same year there was conference in Rio where the ideas of global management of fresh water were outlined. Since 1997, every 3 years we have the meeting of the World Water Forum that I already mentioned. And another thing that I would like to mention here is 2000, The Hague, second World Water Forum, when for the first time it was recognized that it's necessary to form integrated management of water resources and outlining of methodology and practice. If we mention just the legal provisions regarding management of water resources, we decided to have a very simplified slide using the example of such cells. And if we talk about the direction, so first of all, the main direction is science and technology direction, when international agreements outline the indicators that should be applied by different countries. An example is Helsinki recommendations, HILCOM recommendations. The next, organizational legal. Well, organizational legal, first of all, I'm talking about the unification of the system of management of water sites. And then we have the integrated system of management of water resources. So the essence of integrated management of water resources is in the ratio of the elements economic, environmental, social, that must be harmonized in all the ways, and we must have sufficient number of those so that they actually help to manage the water resources. And another venue is unification of the necessary definitions and notions, and also creating the core of experts that, notwithstanding national jurisdiction, should work in the same professional space. And Vodokanal of St. Petersburg recently joined the idea of creating of International Water Academy, and we hope that in the foreseeable future we're going to have it as the basis for the development of different topics dedicated to safety of water resources. I'm a moderator, I shouldn't speak long. That's why I would like to give the floor to a professor of Helsinki University, Mr. Kaikokka. I was getting ready. That's why I wanted to tell you that Mr. Kokka is dealing with environmental legislation since 1996. And he was teaching, he was a professor, a researcher, coordinator in Helsinki, in Turku, in the Eastern University of Finland. And his professional interests are multiple, but they're all connected with environmental legislation. Lots of publications, lots of research published. So you have the floor.
Okay, thank you very much. Ladies and gentlemen, it has been a pleasure to be here in this beautiful city and nice colleagues as well. I like to bring a new approach, a little bit new approach. This is not really the water law, this is sustainable mining and environmental regulation. And it links to actually brand new research results. I used to work at University of Lapland earlier, and I studied at the University of Helsinki during the last year, August. Finland, in plenary session was mentioned actually this Eurovision Song Contest, and Russia was managed very well there. And Finland was not so good, I would say. But in one contest we have actually managed quite well. Fraser Institute is doing every year survey concerning mining and investments, attractiveness of investments to different countries, mining investments. Actually, survey is done in 122 countries, and last year and also in other years, Finland has managed very well with this survey. Actually, last year Finland was the first one. And the idea is that from the mining companies is asked the opinion about the countries and how attractive they are. And I guess we have done at least something right in Finland, although we are not so good in song contests. So about the background in my presentation. Next slide, please. Or have we this? Yes. Thank you. Here is the research project which I mentioned. We had made comparison between Russia, Sweden, Norway and Finland. And we also had very nice Russian colleagues, researchers from Murmansk area. And it was successful project. During the 2 years, we actually got 9 interdisciplinary referee articles and so on. When I have limited time, I just take some issues. One question is, what is actually sustainable development in mining? How mining then links to cross-border issues? In fact, it is so that mining companies are international companies, and they usually have daughter companies in different countries. And so the same companies can have mine deposits in Finland, Sweden, or Finland, Russia, and they have own self-regulation in this global world. So in that sense, it is normal that companies actually work in different countries and then also cooperate not only in self-regulation but also study what kind of public regulation is in these areas, and especially environmental regulation. And sustainability is, of course, important issue. And when we all know that mining, especially open pit mines, have influence on environment, then we can ask that what is actually sustainable development in mining. I tell something about this comparative study done during these 2 years, 2013 and 2014, and then conclusions. Sustainable development in mining. I think all listeners have heard this sustainable development, what it means quite often. But what we looked for, we actually thought that how these different aspects, economic, social and environmental dimensions, how they were balanced to each other. In this sense, the concept is abstract, but we of course went to the more realistic level in our study. Environmental sustainability, especially when we talk about the protection of ecological processes, it is tough not to extractive industry. But we can use environmental regulation to limit these effects. And what is important here is that also economic aspects are taken into account and social aspects. So sustainability of mining is actually balancing of these different dimensions. If we have a very rich area, ecologically rich area, then of course we have to be careful if mining can be, that there can be mining deposit. So then probably the ecological issues are more important. But if there is a very rich mineral area, then of course we have to take into account, is it possible to somehow protect nature in some other area? So we need this balancing in this sense. I would say that it is not easy job, but anyway, we have to try to do it. We studied 4 issues actually. The framework and functionality of environmental regulation, the competitiveness of the mining industry, public participation and possibilities of local communities to influence, and the protection of Sami cultural rights. And now I concentrate the first and second issues. In all countries studied, the minimum level of environmental protection for mining activities is set by regulation. In spite of these serious implementation gaps were in all countries, still we need better regulation, smarter regulation. Especially problems were in coherence and consistency and legitimacy of relevant legal processes. The results of the project indicate that the proper interaction and equality between mining laws and other environmental laws, it is very important aspect. And also that the legal framework should provide room for adequate public participation, not only in mining projects, but in general big projects. Unfortunately, this is quite hard to see this slide, but I explain the main part of it. Okay. The first slide concerns environmental impact assessment. And then we studied all these countries and had also empirical studies, interviews, and in every country is actually legislation for environmental impact assessment procedure. But in Russia, scope of mining was limited in EIA process, so that it is limited to some valuable areas. Also concerning transboundary EIA, all countries, Finland, Norway, Russia, Sweden, has been parties in Espoo Convention concerning transboundary EIA environmental impact assessment, but Russia is not ratified yet the convention. Because of the scope limitation of scope in Russia, public participation is also limited in mining projects. So what we learn from this, it is important to have self-regulation of companies to compensate this aspect. So some recommendations for socially sustainable mining. Social sustainability is a key factor for development of mining industry. Social impact assessment is more than a facet of obligatory EIA procedure, and also minimum level EIA is needed, but it not guarantee. We need a voluntary wider social impact assessment during the whole life cycle of the mines. Thus, self-regulation of the companies is important to earn a social license to operate, acceptance of local people for mining. And the second part concerned environmental permits. Norway was not part of this analysis. There was only Finland, Russia, and Sweden. And all countries have national legislation concerning environmental permits or ecological issues, like Russian says. And there, like I said earlier, is need for some improvements. Here is 2 questions concerning this matter, and I only go to the answer. Empirical studies overall in all 3 countries, and regardless of some important differences across them, a lack of timeliness and predictability in environmental regulations has constituted a significant obstacle, or at least limitation, investing new mining operations. What this actually means. Here is the picture saying the terms. It says actually that it is important to have enough time to comply standards. It is not a problem that we have strict environmental standards, but compliance time should be wide enough. And that's why is needed flexibility in regulation, environmental regulation, and also predictability so that the companies can get information beforehand, for example, what happens in environmental permit procedure, how long it takes about, and such issues. So some recommendations concerning this matter. With regard to competitiveness, SUMILCERE study calls for 4 improvements: improved resources and competence of authorities. This is also a very hot topic now in Finland because we have a new government, and the new government has actually decided to save costs about 4 billion euros and costs from public authorities, for example, and also from environmental issues. But our results actually says that there should be enough labor resources and enough people to make these permit decisions and also negotiate with companies so that the competitiveness level stay high in countries. New governance is needed, administrative tools, stringent performance standards in combination with extended compliance periods, and also roadmaps for example, environmental impact assessment and also public participation. Conclusions. I skip a little bit. I'll just say that self-regulation is very important to fulfill public standards, obligatory legislation, and social license to operate is quite well known in Finland already, and it is used, but it is not actually quite familiar. For example, in Russia, we noticed that in Russia is usually talked about this corporate social responsibility and voluntary participation part of this corporate social responsibility. Actually, this corporate social responsibility is one issue where we Finns can learn also from Russia. Sustainable mining calls for balancing economic, social and environmental factors when seeking best environmental regulation and practice. In general, studies show that all aspects of sustainability are deeply interconnected in terms of social impact assessment, not only environmental impact assessment, but social aspects as well, social license to operate, and also corporate social responsibility. We also studied the protection of cultural rights of Sami people because this was in Arctic area done project, but I have not taken the results into this conclusion. So, in fact, sustainable mining industry can be competitive with strict environmental standards when the regulatory framework is predictable and stable, flexible as regards compliance, and sufficiently consistent, and anyhow without compromising environmental protection for future generations. Then we can talk about sustainable mining. Thank you.
Kiitos.
Thank you very much. I would like for us not just to speak one after another, because if there are some questions, let's ask them right away. Moreover, we are aware that according to United Nations, the cleanest quality of water is in Finland. And last year, speaking in our round table, the Chancellor of the Ministry of Environment of Finland, Madam Hanneli-Pokka, was saying that thanks to the engagement of Finland for more than 50 years in agreements of UN, EC, the adoption of Aarhus Convention, the participation in Espoo Convention, the environmental protection, right to health, to life related to clean environment. It's all endorsed in the Constitution of Finland. And the Espoo Convention, is all about the fact that if Finland is doing the prospecting or doing the development, their outcomes of which could impact cross-border countries, they are obliged to inform those cross-border countries, your neighbors across the border. So if you may ask questions right away into the microphone, and I'm very glad that the law school of our university is present here, because Madam Hanneli also mentioned that cooperation between universities is very important, and I also mentioned that there should be a core of specialists who are like-minded people. Then we'll protect our natural resources. Are there any questions? Use the microphone, please. Introduces Viktor Naboychenko.
There are some discussions in some countries, for example in Norway, about the following leverage with regard to putting some reasonable pressure on not very friendly environmental techniques of some company. I'm talking about limiting the state ownership in the companies or the funds with state money in the companies that, for example, have coal production, and recently discussed draft law in Norway is just a picturesque example of this thing. How would you evaluate this as a general tendency? Is it a future trend to your mind, or it's one-off thing which is applicable only for Norway and those particular circumstances? How would you evaluate in general the role of the government in this regard, just putting a ban, sending a very strong signal to companies that are using outdated technologies? Thank you.
Well, I'm not good answer for Norwegian situation because I'm not Norwegian lawyer, but I suppose that in general situation is so that we need more minerals all the time. So new deposits are open in different countries, and for example in Russia and Finland we have some rare metals, and which are important, for example, in our mobile phones. So I'm pretty sure that governments somehow like to give possibility to new investments to countries, so that they try to make it as attractive as possible. But at the same time, it is like, which is our message, that it is same time to take care of environmental matters. And the message was that the strict standards is not actually the problem for investments. But it is important that regulation is clear as possible and coherence. So it helps to make these investment decisions. And if the private investments is done to the countries, then of course government's role is more like a public regulator and set particular limits for pollution and so on. But the main operators are the private one. Of course, in Finland we also have actually state is a shareholder in some mining companies, but it is still they work like a private companies, and my opinion is that it is actually the private money who is going to make the investments in the future. Yes.
Да, пожалуйста. Ольга Александровна Жаркова, доцент.
Olga Zharkova, Associate Professor of the Chair. I am representing the university. I have a clarifying question. Correct me if I'm wrong. In your presentation, you were saying that there should be self-regulatory unit in the companies in the mining sector. In Russia, it's unclear what kind of self-regulation could there be in the use of subsoil. Is it about the activity which is related to development of the deposits, or is there some self-regulation in using the subsoil? Expand on self-regulation issue.
I must say that I was a little bit hurried with this matter, but our idea was to study especially social impact assessment. We have noticed that it is important issue in the sense that when you know social impacts in local area, then it is easier to get the acceptance from local people. And after that acceptance, of course, you can get this social license to operate. Then you do not probably have less problems in the future when you're working in that area. And it is not only just when we're talking about private companies, it is not only a matter of, well, we don't have access, what it means. It is actually very important, especially daughter companies. They may lose possibility to get funding from private financial sector if they don't have a local acceptance, because then it is risk for financial sector. It is social risk that something happens in that area for the mine and it does not get, for example, environmental permits or something like that. And it may lead to the situation that it is difficult to get funding for the mine. And we have actually one unfortunate example also in Finland in this kind of situation. They didn't actually made I guess, social impact assessment as well as it should be done, and it is one reason why. And they also had difficulties with environmental regulation, and they lost the social license to operate. And then there was difficulties to get funding. Yes.
Professor, I'm from Sri Lanka, and I deal with a lot of environmental issues. Just as a matter of interest, on the assumption that sustainable development was permissible, how much of weightage would you give social impact assessment in deciding whether a development was sustainable?
It depends, of course, the situation. When we're talking about indigenous people, then cultural issues and like, for example, in Lapland, reindeer herding is important for Sami people, and also some other cultural aspects which may influence is it possible to have a mine in the same area. And in this kind of situations, there should be find decent solutions how to compensate, for example, loss from reindeer herding, or even think that is there any other possibilities to make a mine underground or something like that. Yes.
So am I to understand that however sustainable the development may be, that can be overwritten by the fact that the social impact assessment is far greater. Can that be so?
It is balancing issue. Of course, when we're talking about, for example, ecological limits, it is clear that not everything is allowed. There is particular limit for that. But then we also have a gray area where it's possible to balance things. And I think it is important aspect.
The reason why I asked you is we had a phosphate mine near ancient ruins, and the courts struck it down, and we had to readjust the whole program at one point in time. Thank you.
Спасибо большое.
Thank you so much. Thank you, Mr. Kaikoka. But I would like to ask you another question. What do you think? Implementation of environmental projects, is it more of private law or public law?
Both. We need, of course, and law is not all things.
А соотношения, приоритеты?
But what about just the ratio and priorities? I believe that if we have time left, we'll discuss it, but because law is something above it all, and if you work in law, well, but it's not everything, unfortunately.
I can take one example. It is mentioned that in Finland it is needed at least 30 different permits, administrative permits for the mine. Probably it tells that at least public law is very important in mining. Yes. Is this enough?
Да, спасибо.
Yes.
Спасибо.
Yes, thank you. And now, with the greatest pleasure, I give the floor to the speaker of Environmental Desk of 2014, representative of the Ministry of the Natural Resources of the Russian Federation, Lyudmila Kanaeva, head of the Department of Water Legislation of the Legal Department. So, good afternoon. I wanted to dedicate my presentation to the implementation of the Russian Federation of international obligations regarding trans-border water sites. So that's implementation of international law, Russian legislation. And as Marina told us, we are talking about the 60th Helsinki Convention, also UN Convention, and the Russian Federation is a party in this convention, and also the Russian Federation is a party of 9 bilateral agreements regarding trans-border water sites and 1 trilateral agreement on Pass River, Finland and Norway. And if we mention the countries' Russian Federation borders regarding cooperation in water sites, and 9 bilateral agreements were signed by the Russian Federation with Belarus, Kazakhstan, China, Mongolia, Ukraine, Finland, Estonia, Azerbaijan, Abkhazia, and trilateral agreement Pass River, Finland and Norway. And in the field of implementation of the obligations in the framework of bilateral and trilateral agreements, joint bodies were created, joint commissions, bilateral, trilateral commissions, and in the framework of every commission they have joint groups regarding monitoring of the situation in water gathering territory, also water body and trans-border flows. And when we're talking about their priority in the work of this commission, the priority is in comprehensive use, in integrative use of the water resources, agriculture, industry, fishing, so hydrotechnical. I don't understand. Is it mine? Something is wrong with the sound here. Is it the phone or what is it? No, it's not my phone. No. No, it wasn't like that before. And we're going to talk a little bit more about the event, but actually regarding transborder water flow, the legal status of transborder flow in the Russian Federation is not determined by the water code of the Russian Federation. We don't have such a notion as transborder water sites. Legal status and the competence is not divided. And the water code of the Russian Federation also the jurisdiction is not divided regarding different agencies of the federal level. And regarding monitoring, the monitoring of transborder water sites is in the jurisdiction of for about 40 agencies of the Russian Federation, Ministry of Natural Resources, Rosprodnadzor, Minsельхоз, Russian Fishing Agency, Comercon, FSB, Ministry of Defense, and so on. We can talk about large number of different agencies that conduct monitoring and also guarding of those sites. And in the Russian legislation, we haven't defined the term transborder water sites, and the competence is not divided, and also the competence of the regional agencies is not divided, and that's why we have quite serious issues regarding funding of those activities. And for example, now we have very serious issues regarding funding of the agencies that monitor the water flow in the Russian Federation, and they're supposed also to monitor transborder sites, because there is no special entry in the budget regarding monitoring of the situation in transborder flows, and the agencies that should conduct monitoring in the framework of the budgetary funding, they must find some funds to monitor transborder water sites. And these agencies, well, they're talking about insufficiency of those means, because monitoring of transborder water sites provides for more complicated hydrological analysis, and this is not just the monitoring of the water zone, but this is the monitoring in the territory of water collection. And again, there is the systemic approach, comprehensive approach, and quite often in transborder water cooperation, we're dealing with the transborder reserves. For example, we have that with Mongolia, on the basis of specially protected natural zones, transborder reserves are created. This is also a protected territory, but it's of international significance. And what else could I tell you about? And regarding implementation of the provisions of international law, we have to welcome the fact that now we have the law on the best available technologies. It was passed in order to stimulate water users to build special filtering equipment and to provide tax privileges for that. And everything is reflected in the law. I believe that the majority read the law. I'm not going to dwell on the text, but it's part of the development of the legislation, which is going to guard transborder water flow. And regarding the ratification of the convention, regarding the influence on impact on the environment, and the Russian Federation since 2011 has been conducting very conscientious work regarding ratification of this convention, impact on the environment, and the draft laws were outlined, and these two draft laws, not just regarding ESPO convention, but also on the Convention on Access to Information and judicial proceedings, and the draft laws on ratification of the conventions, they were outlined in 2013. Lots of necessary approvals were gathered, but the president decided that before we ratify, we should outline all the necessary bylaws, so that in case we take additional international obligations, we have the mechanism of implementation of certain provisions, and we can take the obligations and do it properly. As the result, we had two directives adopted. One R directive. This directive establishes the plan of action to implement the obligations taken. The implementation plan is till 2019, and this is the process that started in 2014, and the plan is till 2019. And there is also the 10R directive regarding implementation of the laws and bylaws to implement ESPO Convention. It's not just ESPO Convention, but also the Protocol on Environmental Assessment. What is provided by these plans? If you are interested, I could read it out. The implementation of the plan is outlining of the draft federal law regarding introducing changes and other legal acts in the part of providing the notions transborder impact and strategic environmental assessment. These assessments don't exist in Russian law, and we couldn't ratify this convention right away. We're talking about establishing the requirements regarding influencing the environment, and also conducting of the consultations regarding impact on the environment, and also the government agencies should have the AVAS measures, and also to establish the procedure of AVOS and strategic environmental assessment. I would like to mention that Russia is a party of the convention trans-border impact of industrial accidents, which is going to prevent possible hazardous effect of the accidents in water sites. Here we're talking about oil spills and maybe some other waste. And last year at the roundtable of the Legal Forum roundtable, we discussed the fact that the competence was not divided, and I will tell you, 1993 document regarding the trans-border impact of industrial accidents, and the Ministry of Natural Resources of Russia was supposed to do everything, coordination and cooperation with neighboring countries. In the course of 10 years, more than 10 years, the jurisdiction of the agencies was changing, and also the changing regarding accidents, emergency situations. And we know that Comercon is in charge of emergency situations, and regarding protection from industrial accidents. Rostechnadzor is the agency which is authorized to participate, and there are many other agencies that could participate in implementation. And finally, the Russian Federation accepted the document August last year. I don't remember the number. And that directive established the list of agencies that are responsible for implementation of this convention. And here we're talking about a Russian Fishing Agency, also Foodstuffs Supervision, Ministry of Defense, Ministry of Foreign Affairs, Ministry of Natural Resources. And frankly, we wanted to give the coordinating role to Rostechnadzor, but somehow, well, because it's environmental protection, the government decided that it was necessary to provide the coordination role to our Ministry of Natural Resources. Well, that's regarding industrial safety. I believe that I talked longer than I had to. Well, regarding the events that somehow are conducted in working bodies of the Commission. Well, we don't listen to the Ministry of the Water Resources, Natural Resources representative. Maybe we could ask you questions. I believe that I'm going to finish my presentation. If do I have time? Thank you. Well, because I mentioned that we are developing Russian legislation in the field of international legal cooperation, and we have bilateral, trilateral agreements, and what is written in those agreements, and what kind of information is required, and what kind of activities are conducted. In the framework of the working group, we outline and implement bilateral, trilateral programs regarding transborder water flows. Also, we are agreeing on the modes of water use. We exchange hydrology, hydrochemical information.
We exercise joint measures to prevent the reduction of cross-boundary impact upon water courses and the ecosystem per se, the formation of intergovernmental system of joint monitoring of cross-boundary water bodies. Apart from that, more important issues related to the approximation and rapprochement of national standards and rationing, unification of methodologies of assessment of the quality of water resources. I would like to dwell on that. Mindful of the fact that the monitoring is very complex and complexly structured. Oftentimes the data from Russian Federation monitoring data and those of cross-border countries might not coincide. We should unify methods and criteria of assessment and forecasting even of different situations by simulating oil spills and things like that. Of course, technologies are very important. It's just most desirable for those technologies to be available for each party which is participating in protection of cross-border water courses. It's very important for us to have this communication between the experts. Oftentimes with China, we have an exchange of those groups when they come along to the site, let's say hydrological site, and they come with the inspection on to our sites, and we go to their places. They do monitoring if everything is right. It's not about homeland security, but it's about hydrological, hydrotechnical sites. They are available for monitoring. One more very important thing is about mechanisms of reimbursement of potential damage, indemnity paid. Let's say there was an accident, like there was an incident on Amur River, which damaged other countries' population as well. It was very hazardous for them as well. It's very important to have international cooperation in this sphere as well. And joint scientific research, joint projects, and different authorities I mentioned, they are also participating in those joint projects. Those agencies whose competence is monitoring and protection of cross-boundary water courses. That's about it. If you have questions, please ask them. Well, we would like to thank Mr. Kokka and Mr. Kanaev, Madam Kanaeva. Let's put our hands together for them now. Are there any questions? If you allow me, I have a question. I'm from Vodokanal, St. Petersburg. Ludmila Anatolievna, in your presentation, you repeatedly mentioned that in Russia there is insufficient legal regulation in the sphere of protection and rational use of cross-border water courses. That's the way it is, I think, and many conventions you mentioned, and which Russia is going to ratify in future as well, are of declarative nature, but at the same time they are binding about specific regulatory framework we should put together. But there is not very pleasant phenomenon altogether in legal practice, such as a competition of law. One national jurisdiction can compete against another national jurisdiction, and sometimes it's rather adverse competition. As to the federal authorities and your ministry, for example, do you have a clear vision as to how the mechanism should be formed? The mechanism of protection of legal national sovereignty, to protect our legal sovereignty from unauthorized impact on behalf of foreign jurisdictions. Let me specify. We're speaking about fair competition, of course, a good faith competition. Well, in this particular case, it's not so important whether it's fair or unfair competition. We're talking about the management of cross-border water bodies. There should not be competition at all, period, because these are strategically important things which should be regulated by national law. Yes, your question is of strategic nature, because everything which is related to national sovereignty are of highest priority, and neither contract or agreement would be signed unless there is voluntary consent of this or that part of country. It's all based on voluntary principles. Of course, countries make, let's say, bilateral agreement on the use or preservation of this or that cross-border body, only provided they are going to remove the problems jointly when it comes to water supply because this is a finite resource, and about water quality, to jointly not just to monitor the quality, but to clean up water, to have some environmentally protective efforts together. Along those lines, I don't see any personal interests which might, one way or the other, violate competition. What kind of competition are we talking when it's all about the declaration of intention of a state which signs an agreement with another state, an agreement on protection of this resource? Another thing which evolves in line with the previous one is when within the same convention on cross-boundary water courses, the measures are taken by some agencies, let's say Committee on Implementation. This is the Convention on Cross-Boundary Water Courses. This implementation committee was set up about 3 years ago for consultancy purposes, to support with consultations on implementation of this convention in those countries which cannot cope with that on their own. It's scientific support, methodological support, criteria, calculations, evaluations. But this committee on implementation, in most likelihood, does not quite clearly understand their competence in this issue and starts interfering into relationships between the countries which are not even signatories to this convention on cross-boundary water courses. Just by one example, Kazakhstan, Russia, and China. China is not a party to the convention. Nevertheless, as we are sharing Irtysh River water basin between our three countries, Kazakhstan, Russia, and China. And in Kazakhstan, one of the NGOs decided to turn directly to Convention Bureau, to the implementation committee, asking them to resolve this issue of the level of water, because allegedly China grabs all the water effluent to China, to their own country, and nothing goes of this water goes to Kazakhstan. That's what NGO was saying. And for the second year on the row, by international channels, Russian Federation receives official letters asking what is happening. Do report us on what happens on Irtysh River, what happens to Kazakhstan and China. And we repeatedly said that, sorry, but China is not party to a convention. Russia did not declare the consultancy as help. Kazakhstan was not seeking explanations and consulting services on this issue. That's about breach of national sovereignty. So what was the purpose of setting up this committee on implementation? It's not an arbitration forum or arbitrage court. It's not a supervising agency. Why should they interfere, and interfere not on the initiative of federal level agencies, but on a complaint? I may say it's just a complaint of an NGO. Yes, it's environmental NGO, but we all know, maybe I'm going to say very provoking thing, but there are many NGOs, ecological, environmental NGOs and others, which one way or the other are being sponsored by some countries who are competitors to us in those things. You should be aware that unless the state, the country seeks aid, seeks help, assistance, neither international community, neither international agency is entitled, is allowed to interfere into the issues of national sovereignty. Thank you. Microphone. The button is not pushed. You spoke about environmental impact assessment and others. Does ministry provide for risk assessment tools? Maybe jointly some strategic decisions might be elaborated in future, and also the joint control of the risks. No, we didn't have this task. I think this is for future, after we ratify environmental impact assessment, then we'll be more specific about different issues and risks as well. But everything which concerns risks, I also had an idea from the environmental standpoint. Maybe we should do the assessment of impact the Ministry for Economic Development is doing for businesses. All the federal agencies of Russian Federation exercise assessment of regulating and regulatory assessment in order not to push the businesses, not to exercise pressure on the businesses. So they conduct this assessment. Federal agencies are controlling all the activities which could, at the end of the day, have adverse impact upon the state and the population and environment per se. So maybe in future we'll see draft laws, I hope, about the necessary assessment of regulatory, assessment of all the decisions, assessment of all environmental risks which will be impacted by the governmental decisions. When theoretical issues are raised, this is very important, but as the public official, I know that now it's not implementable, but ideally, in theory, it might be possible to have this kind of assessment as well. Risk assessment, assessment of ecological risks, that would be wonderful, but now they are non-existent. I mean, the assessment is non-existent. More questions? Thank you. Now I am privileged to give the floor. And my apologies if I put the syllable, the chairman of National Green Tribunal of India, Kumar Shvetandra. I hope I pronounce your name in the right way, otherwise I'm sorry about it. Talking about the biography of Mr. Shvetandra since 1971, he has been working in different jurisprudence positions in the courts of different instances, also ecological law, and since 2009 he was appointed a judge of Supreme Court of India. Presently he stepped down and he is the chairman of National Green Tribunal of India. What else is very interesting? And I recall now that a while ago in the education of lawyers in Russia, always they had the classes of acting, like in the theater. Mr. Shvetandra is a Bachelor of Arts. That's great. Floor is yours, Mr. Shvetandra.
First and foremost, the distinguished delegates, our great host Russian friends, I would like to convey my sincere good wishes and thanks to the legal forum, which deserves a high compliment for organizing an event of international character and at that magnitude. Thank you for inviting me to speak at this great event where great thinkers and opinion makers are present. I was just thinking, ladies and gentlemen, that no matter how rich are you, how poor are you, what is your status in the society, but two things are certain. You need clean air to breathe, you need clean water to drink. Human life without the source of environment is futile or probably impossible. Is it not quite unfortunate? And now to be on the lighter side, please don't take me seriously when I say that. Today, the environment has been placed as one of the last topics for discussion of this international conference. And very few people have opted to participate in this. I call it unfortunate that something without which we can't live. We cannot have a future, but we find it difficult for having serious deliberations on that subject. My topic, which has been assigned to me by the organizers, is with regard to cross-border environmental protection with particular reference to natural sites. A new geography of social and natural process is taking shape as a result of globalization and the shift in economic and political activities worldwide. The consequences of this are manifold, ranging from social conflict to environmental degradation. A key issue is the impact of the development is having on the environment, especially on natural sites, not only of developing countries, but also developed countries, and the world as a whole. Most important of that is that the faces of the international community, and that is the most material question, is how to protect our environment against the demanding needs of the development. The little experience that I have in the field of environment, its protection and adjudication thereto, I have come to realize that it is in fact an indefeasible part of subsistence and well-being of a nation that its citizens. I am often reminded of Gandhiji, what he said once: there is sufficient in the world for the man's need, but not for the man's greed. This is when we shift to the later phase of this phrase, that it causes total injury to the environment, which is most of the time irretrievable and irreversible. I am certain that all the ones who have gathered here are clear and would say undisputedly that environment knows no geographical bonds or boundaries or national boundaries. In fact, in the same fashion as the environment, the environmental pollution knows no limits. It knows no boundaries. And it touches the far higher peaks of Himalayan in the same way as it affects the sheets of ice of South Pole. Its pangs are felt by every human being, no matter what part of the world the person lives. If we look into certain data with regard to the natural sites, South Asia is also a home to a significant but shrinking era of terrestrial and marine biodiversity. For example, the Hindu Kush Himalayan belt is home to 25,000 major plant species, comprising 10% of the world's flora. In addition, Sri Lanka is one of the most biologically diverse countries in the world, and India contains extensive swampland and forest habitats, including many endemic specific species of international importance. South Asia also has around 14% of the world's remaining mangrove habitat in addition to the highest percentage of the threatened wetlands, majority of which are even in Bangladesh. It is interesting that South Asia approximately shares 90% of the Asian and Pacific region total forest cover, providing cross-border habitats for a wealth of species. But all this, whether in terms of wetland, whether in terms of forest, whether in terms of what we are calling as natural sites, rivers, all this today is threatened. It is threatened because of invasion by the man. Human conflict with nature is leading to some very serious consequences, which today we are seeing. One in the form of global warming, you talk of other natural disasters, calamities, or the man-made disasters. See the variations. 188 cases of illegal wildlife smuggling were reported between 1992 and 2007. According to the Forest Protection and Surveillance Unit, under the Department of Forest and Park Services, the number of cases drastically increased in just 2 years. 114 cases of wildlife crime were recorded between 2008 to 2010 alone. The booming wildlife trade has been attributed to the dire economic conditions in some parts of the Asia. Similarly, let's just look at the various border issues which relates to this concept or this branch of our environmental jurisprudence. Cross-border wildlife conservation. With expansion of human settlements around the Kanchapur Forest Division in Nepal, since 2004 to 2005, there has been escalation of accidents of human-wildlife conflict in nearly villages of both India as well as Nepal. The Tangle Forest of Sundarbans, covering over 10,000 square kilometers, are home to Bengal tigers, river dolphins, and other endangered species, and also protects the densely populated Bay of Bengal from cyclones and the worst extremes of nature, is now threatened by the land reclamation, lodging and shrimp farming, rising sea levels, and dwindling fresh water from Ganga River. Trans-boundary water issues. In the past decade, there have been many disputes in different countries, and mostly the neighbor countries. As China and India struggle to grow, provide for their citizens, and expand their respective roles as major players on the world stage, the two countries are increasingly facing water constraints. This challenge is made more complex by its shared nature. Much of India's river water originates in China. Of the river waters that cross the Sino-Indian border, the most important is Brahmaputra. The Brahmaputra River flows for more than 2,000 miles through China and India and Bangladesh on its journey from Himalayas to the Bay of Bengal. Wetland and coastal regions. Recognition of the transboundary wetland reflects a commitment to conserve habitat rather than individual species. However, at present, there are only 16 formal transboundary agreements out of 234 confirmed transboundary wetlands. The Ramsar Convention is an international environmental agreement addressing wetland conservation with a key provision that acknowledges wetlands may transcend political boundaries. Transitory and wetland have been defined under this agreement. In 1992, at the United Nations Conference on Environment and Development in Rye, The recommendations were given to the coastal states to develop and implement integrated coastal zone management programs in line with their local condition. In last 20 years, interest in IJM has developed a global character, and now all over the world, countries are implementing such programs or examining foundations for their realization. Over 50 countries now participate in approximately 150 ICJM programs. Requirement of establishing greater enforcement agencies. This I make an attempt to visualize, is it all over, or we do need to do something very constructive to find out the ways and means to maintain our wetlands, our forests, rivers, and all natural habitats. In this, the suggestion is, ideal situation would be the society can work without reference to justice administration system, particularly in the field of environment, but it falls clearly beyond the domain of prudence and prudent comprehension. There is a need for alternatives beyond domestic courts to resolve cross-border issues relating to preservation of natural sites. The barriers in enforcing transnational environmental laws must be realized whether they are financial or legal. We all know that transitional litigation is more complex, both factually and legally. There must be a consultative adjudicatory process where all the stakeholders must be encouraged to participate, and there must be a decision which is agreeable by all. There need to be a global concept jurisdiction in which the aggrieved state or persons may be permitted to claim environmental protection, whether harmful event took place or where the event of such event are being observed. Most importantly, I would think, domestic law interpretation in complete line with the environmental jurisprudence at the international level, so as to enable the application of country laws to be achieving the objective of cleaner and better environment. Rule of law. Rule of law is the basic rule of governance of any civilized policy. It has been derived from the French phrase of la principe legality. A government based on principle of law. In simple words, the term rule of law indicates the state of affairs in a country, where in the main the rule of law governs. It is a dynamic concept and does not admit of being readily expressed. Hence, it is difficult to define it. Simply speaking, it means supremacy of law or predominance of law. Essentially, it consists of values. Promoting the rule of law at the national and international levels at the heart of United Nations mission. Establishing respect for rule of law is fundamental to achieving durable peace in the aftermath of conflict, to the effective protection of the human rights, and to sustain economic growth and development. Need for formulation of uniform laws. There are over, strangely, 1,100 multilateral and 1,500 bilateral international treaties and convention agreements. To formulate laws, it is essential that there is a greater coordination and cooperation among nations, enabling them to establish uniform principles after studying a comprehensive law overview of the various approaches used in this respect. A regulation framed for enforcing transitional environmental protection of natural site must provide for civil action by public authorities, ensuring compliance of environmental law and principle. The scope of such regulation must be construed in light of the wider environmental law contexts. The approach towards environmental issues should be liberal, while ensuring sustainable development, as well as access to justice, and states must ensure that recourse against the relevant private party is available through a national law for victims of transboundary harms. Further, there must be harmonization, ensuring that the national law are amicable and are in line with international field. As we refer to so many laws, it is always easier to create ways and means to breach the law, to flout the law, but it's very difficult to implement and enforce the law effectively. Need to increase cooperation on legal aspects. Besides reformative, punitive, and preventive steps, the requirement of resolution and spreading of environmental education are absolutely essential facets of environmental protection. Shared management of natural sites provided an opportunity to build trust among neighbors, hence the prospect of ecological diplomacy. Enlisting the scientific process into diplomacy can address issues of certainty related to forest and hydrological sources and help create more resilient agreements. Ecological diplomacy seeks to elevate these compounding problems using shared conversation projects to build trust and cooperation and thereby contribute to building the space. In a major boost to the border wildlife conservation, India and Nepal have recently joined hands to secure the key Boom Brahmadev corridor connecting the Haldwani Forest Division in Uttarakhand and Kanchapur Forest Division in Nepal. The corridor is significant passage for tigers, elephants, rhinos, and other cross countries. There are a number of other agreements which have been entered into between the neighboring countries in the South Asia, but it is primarily the understanding of implementing such agreements that would be of some consideration and value. Two things I would like to share with you, which I would call as first-timers. Something that happened for the first time as far as the human memory goes. First is, it may be a very relevant factor for your information, that there is a temple in India, in South India, which is called Meenakshi Temple. This was constructed 3,000 years back, was renovated 850 years back, when we didn't know the spellings of environment. That time they provided for, there is a image, circle created, which is called Bhogola Chakra and Khagola Chakra. One relates to universe. It even provides from under the ground, under the sea, and declares the ozone in those days. How would you protect it? How would you purify your air? It is today written in that temple, which was made years and years back. I thought this was one of the most first events that one could relate back to environmental sciences. The second thing I would like to mention is the Supreme Court of India, for the first time in the world, declared right to decent and clean environment as a fundamental right. Fundamental rights not contained in the Constitution, but by a jurisprudential interpretation systems, it was declared to be a fundamental right. This is the other thing I would like to bring to the notice of this August gathering. What we are looking at is, before I really come to the end, I would like to mention a little about, I hope if I cross the time, please feel free to tell me. The thing I would like to mention to you is something about the organization I belong to. I happen to be the chairperson of the National Green Tribunal of India. This is the first tribunal of its kind in the world. Australia and New Zealand have the environmental courts, but their jurisdiction is so narrow, they are more on a regulatory scheme than on an adjudicatory scheme. National Green Tribunal of India, I must compliment the legislature of India and the parliamentarians who could think of enacting such a law which has such wide jurisdiction. We have to just mention to you what it defines as environment. It's very interesting. Section 2C of this act defines environment to include water, air, and land, and the interrelationship which exists among and between water, air, and land, and human beings, other living creatures, plants, microorganisms, and property. I don't think you can think of anything. Therefore, under this act, we enjoy a jurisdiction of three kinds, which is appellate jurisdiction, original jurisdiction, and then we have jurisdiction of special compensation and determination of restoration of damage to environment. There's nothing under the sun that you can do in India without getting through the environmental laws. I think India needs to be complimented for being so environmentally conscious. In our jurisdiction, what we are doing is that if you're talking of a nuclear plant, you're talking of a hydro project, you're talking of an industry, you're talking of chemical industries, they all are subjected, all orders of the government granting environmental clearance or declining environmental clearance are appealable to us. All pollution control board orders are appealable to us. What I intend to say is that we have a three-dimensional administration of environmental jurisprudence. First is the regulatory authorities, the government, and then the judiciary. That is the status of the NGT, as I wanted to mention and bring to your kind notice. We have these disputes, what we think are the dispute cross-border. In a federal structure, if you all know, even interstate states can be having the same conflict which you will have at the cross-border national level disputes. Because federal structures, states will enjoy the same status as a country practically. So therefore, we have been facing these disputes in regard to cleaning of rivers, maintaining one state, throwing its pollutant into the river, polluting the next state. So therefore, there has been a greater conflict. With these few words and thoughts that I wanted to bring to the kind consideration of this gathering with regard to these matters, is all I ultimately say is that it is a great poised hope. It's a poised hope, but still a phenomenal hope that the world should come together and work as a team so that once far-fetched dreams of clean and decent environment may be realized. Let us all endure towards this goal while keeping in mind that many of the great achievements were achieved by those who kept on working, and over time we will be able to have benefit of our hard work. Let us forward to a greener and look forward to a greener future, and would like to say in the words of Kofi Annan, who said, "Let us be good stewards of the earth that we inherited." All of us have to share the earth's fragile ecosystem and precious resources, and each of us has a role to play in preserving them. If we are to go on living together on this earth, we must all be responsible for it. Thank you, ladies and gentlemen.
We have time, Mr. Kumar. We have time.
Okay.
Если бы, наверное,
And if we are asked to just pronounce the motto of our round table, I should say environmental protection unites us. Maybe I am doing it in the wrong way as a facilitator, but in 2014 we worked 4 hours instead of 2 hours because we had State Duma deputies in the room, and they wanted to hear from representatives of different countries what works, what doesn't work, and if it works, why doesn't it work? Because we make some effort, we have laws. Yes, we have plenty of time. We are here, we have this working mode. You can go to other roundtables, you can come back to us. Ours is an interesting place. Any questions to Mr. Kumar? Yes, please. If I may, I have this question. And you know that your country, yes, this is really a country, you had complicated history in the course of 60 years. You had some conflicts with neighboring states, and your national jurisdiction, did you outline, maybe a national law outlined some methodology of overcoming the conflicts that you had with neighboring states, all those problems that you had in the framework of the relationship, and how does it yield good results in trans-border cooperation in environmental protection?
Tribunal is concerned, obviously, it has no trans-border jurisdiction. But yes, at the level of the government, we have tried, for example, to give you China was proposing to build up a hydro project right at the border with India. So they were able to resolve, but this was an amicable settlement between them. It was not with regard to any legal pronouncement, either by Chinese law or by the Indian law. It's more of I would call it more of a political resolutions rather than adjudicatory process. But interestingly, since you have put this question of, what I was going to tell you was that the tribunal, it is the first probably act which says that all the three settled principles of precautionary principle, sustainable development, and polluter pays principle, they are statutorily incorporated into the act so that you are governed only by the settled principles. So like every country would have to apply these principles. It's only an extent of how you apply them, what degree do you apply them, how much of regulatory laws are in place, and how assertive you are. But frankly speaking, we have been able to resolve I told you there are around 30 agreements, I didn't even cite them, with Sri Lanka, with Nepal, with China, with Bhutan. We have all the agreements, and this more amicable, and they have been able to protect because the resources, natural resources are common to all these countries. You know, their forests, rivers are common to all of them practically, you know. So therefore, it's more of a human understanding that has worked out rather than any adjudicatory process.
Mr. Kumar, I would like to rephrase the question of Oleg Vladimirovich, which was asked by the representative of our ministry. I'll try to put it in such words. From your viewpoint, what are the principles of international cooperation in environmental protection as priority? Should there be intergovernmental commitments for environmental protection, declarative norms, or should we form special ad hoc intergovernmental, inter-country mechanisms to have sustainable natural use? Maybe we're interfering into the sovereignty of countries which participate in such countries. What should we do in order not to interfere into internal sovereignty of the countries and be cooperative at the same time?
That we are, you're right, sovereignty of any country, any state has to be given the utmost priority. Today, there are treaties, there are conventions signed. So, as I mentioned to you earlier, they are primarily on the field of conscientiousness that you have agreed. Now, in our recommendations, and I must point out to you all that we had an international conference at Delhi, we decided, and the recommendation says that we must have international tribunals even, which must go into these questions, particularly with regard to transnational pollutions or damage being caused to natural sites or otherwise. They all must have the force of law today, because it is very difficult to convince people at the government level, at the political level. Today you have nothing except the treaties, and I am not so sure, with all the reservations, whether the treaties are really serving their ends, whether countries are respecting, even who are signatory to those treaties, in the essence of those. I think we need to get together, and when I said that we need to work together is for creation of law or a legally binding enforceable system which will prevent complete prohibition or degradation of the environment. That's what I would feel.
Спасибо. А можно микрофон?
Thank you. There will be another question.
Just to remind ourselves, isn't there a mechanism in the South Asian Regional Cooperation grouping which is dedicated to the environment and particularly to areas of pollution, whether it be water, air, or particulate matter? Within SAC, which is the South Asian Regional Cooperation grouping, we address the issues of cross-border pollution in rivers and other areas of the environment. Then we also, if you can remember, we had the Asian Judges Environmental Rule of Law programs quite regularly, in which your Chief Justice and your deputies also participated, in collaboration with UNEP, with the United Nations Environmental Program, which I have had the privilege of participating in Malaysia, in India, in Sri Lanka. So there's a continuous review of these issues, which the cross-border issues in the SAC region, the South Asian Regional Cooperation, within that grouping. And that is India, Sri Lanka, the Maldives, Nepal, Bhutan. Within this grouping. And then, of course, we have Bangladesh. Within this grouping, we have this...
But this all, as I said, Justice Marina, is exactly what it is, totally voluntarily.
Exactly.
There is nothing like forcing, which you can like in...
There's no treaty.
Yes. There's no treaty, and there is no enforcement to the extent that, yes, it's a very good understanding, as I said. It's a human effort, but nothing which we can really block.
Yes. And there are databases that have been located in the different regions, which we commonly share and we can access when we want data with regard to cross-border problems.
In point of fact, by summarizing the international act, we are saying that they are over-commendatory in nature. Others are referring to some norms of law, soft law, not hard law. It's soft law, it's voluntary, it's on the basis of agreement norms between participating states. So we got down to our last speaker of today, and I am also passing on this question to Valery Abramovich Musin. I always tell you the information about each speaker because at the environmental ecological roundtables we have top-notch international specialists. Valery Abramovich is the doctor of law professor, correspondence member of Russian Academy of Sciences, head of the chair of civil process of St. Petersburg State University, director of St. Petersburg branch of the Institute of Public Law of Russian Academy of Sciences, chairman of the Presidium of the Center on Dispute Resolution in Law Court of Interparliamentary Assembly, Arbitration Court, member of the College, chairman of the Commerce and Industries Chamber Arbitrage Forum, and also the chair of the Arbitrage Institute under the Chamber of Commerce of Stockholm. He is member of experts councils of intergovernmental and judicial bodies. For more than 30 years, he lectures at Law School of St. Petersburg State University. He was an invited professor to U.S. and Norwegian universities. I couldn't omit all the lines related to everything you do. It's very, very important. Your background is very important. I would like to ask you to tell us about your vision of procedural implications of international cooperation in safeguarding environmental protection. Should we think about setting up no jurisdiction agencies, or is it sufficient number of international or institutional national institutions which are capable of resolving all those conflicts? In the previous roundtable, on the fourth roundtable during the previous legal forum, I was asking this question to each speaker. Tell me, please, if we think that environment is so very, very important, what is missing, what it lacks? Maybe we should create very strong intergovernmental agency, but all the speakers of the last forum said we don't have to do that, we don't need it. Thank you very much, Marina Viktorovna. I wouldn't say that the creation of no agencies is good. We used to say in the old times, the best way to detriment everything is to create a new commission to supervise it. We shouldn't make haste with creation of new institutions and supervisors and so on. Are there legal mechanisms to protect and safeguard ecology? My answer would be yes, there are. These institutions are around. It has been mentioned here, but this issue is extremely important. I'm not going to speak about only cross-border, cross-boundary watercourses, rivers, or whatever. Let's take the world ocean. One of the most detrimental aftermath which might threaten us. It's high levels of oil spills. In 1967, there was an incident between England and France with one of the oil tankers. And in 1969, the convention appears about civil liability and third-party liability for pollution of watercourses in maritime literature, because I have been dealing with the maritime law for 50 years maybe. They say that if we only take the largest accidents of oil spills, if they all happen at one go simultaneously, the entire world ocean would be covered with oil film of several millimeters thickness, mindful of the fact that ocean produces oxygen for our planet. So maybe the mankind would die because of that huge, massive oil spill. That's why environment is so very important, and it unites us. We should save ourselves, rescue ourselves from this great hazard. But of course, this oil spill didn't happen simultaneously out of all those tankers and incidents. Secondly, nature, environment could self-clean itself. Oil goes down to the sea bottom and decomposes there. But mankind should assist nature in doing that, in self-cleaning and in self-repair as well. Because our development, undergoes under two main trends, which are contradictory, go different ways, but they are uniting as well. On the one hand, mankind is interested in technical progress and should not hamper it. When railroads appeared, I remember that in 19th century, in some of the decisions of German courts, it was maintained that the use of railroads and locomotives and trains is very dangerous, but it's not possible to deal without them. Mankind is not able and should not retard the technological progress, but we should somehow safeguard ourselves from hazards. I might tell you, it's common knowledge that for many decades all the tankers are built with double bottom in order to, if there is oil spill, they would mitigate this risk. And also, presently there are special vessels which are picking oil spills, oil slicks, and other waste on the surface. That's technical part, but there is a legal implication as well. Technical progress evoked such a structure, legal structure, as the source of enhanced hazard, which, while it does not preclude operations of the technical equipment, imposes on those who are using this technology the liability. And the convention was also maintaining that, and the previous convention as well. It envisages that, first of all, the liability is concentrated only on the ship owner. I repeat, from where the oil spill happened. The vessel charterer is not liable. Otherwise, it would be very difficult to find the polluter to reimburse the damage. Okay, source of enhanced hazard. They are liable irrespective of their guilt, but this liability should be revoked if the reason of the incident was act of God, force majeure situation. But in oil convention, it maintains that the liability is revoked in case of military actions, of course, but also in cases, in instances when oil spills are due to exclusive emergency, natural disasters and natural calamities. Hence the question. So not all the acts of God, but some emergency natural disasters are the basis for revoking this liability. Previously, that verdict was in the Convention for liability for damage imposed by the nuclear energy. That was the old 1963 convention. As to oil convention, it still retains it. I think we should follow what nuclear convention was saying, and any act of God should be covered by this indemnity clause for pollution. Apart from that, speaking about oil, there is the mechanism of insurance, which could be used in other instances as well. Until up to a specified amount of money, the insurance should be supported by the government, by the state. When this amount of insurance in insured loss is above it, very peculiar, very interesting mechanism is used. International fund for recovery of those damages. But the fees to that fund are made by states importers of oil. That is very reasonable and very rational. So, Marina Viktorovna, you see, if we take a broad look at the international legal remedies, we'll find a lot which could be helpful. It was very interesting for me to listen to the presentation of our representative of the Ministry for Natural Resources. She was speaking at length and she was uninterrupted. And she demonstrated how federal agencies, federal authorities are developing regulatory frameworks. Our foreign international colleagues demonstrated to us that they also have the same instruments. So at the end of the day, if we're using those legal mechanisms which are already existing in national law and international law, we'll be able to be optimistic about our future. I would like to tackle upon another issue, which is a sore point. It was raised by a colleague from Vodokanal. It's about conflict of different jurisdictions. I wouldn't say we don't have this mechanism. We do have it. It's envisaged in civil code. Let it be genuine jurisdiction court or arbitrage court. If the court is convinced that it's the dispute between the same parties on the same merits about the same subject is judged by the international court, which started judging this case before. So we do not consider this because it's international committee principles. We should not entail the situation when our national and international court judgments would be in a collision on the same on identical cases. But that is only done when a claim was brought to the court in another country prior to that done in our country. Or there is another way out. It could be an agreement if the parties agree that it will be this national court who will judge, which will judge this case. So that will be settled like that. Another thing, if this is the case which is an exclusive competence of our court, then we will not enforce it otherwise. But another issue evolves here, which has been resolved within the Council of Europe by the Protocol of 2012.
And here it's not solved. And right here, when here and abroad we have just 100% similar case, it doesn't happen always. Usually it's quite different, because in our procedural codes, in both of them, we have this provision that if this case cannot be dealt with before any other case is dealt with. So you suspend the proceedings. That's inside the country. But if there is a similar case which is examined abroad, our law says nothing. But in the rules of 2012, it says that in this case it could be suspended. Not mandatory, but could be suspended. It's clear that we have this cautious wording, but how could this case influence the case abroad? But the fact that this issue is there and it must be dealt with, maybe we have to supplement Minsk Convention of 1993, or maybe we have to deal with that somewhat differently. That goes without saying. It seems to me that if we use intelligently the legal mechanisms that the humanity already invented, I believe that we'll be able to deal with the dangers that are awaiting us. Thank you for your attention. And so please.
Sorry. I just heard the learned professor. It's great education for us. I just would like to give you two instances of, because over there we have the national level, the law is different than we once traveled to the international field. But I would like to give one our learned other professor gave. Let me tell you the illegal mining we're talking about, what he mentioned in his talk. Now, in state of Meghalaya in India, we had a case where there is a rat hole mining going on without law, without any environmental protections, without any scientific or regulatory mining being done. This mining is going on for years and years and years. You had the young boys are used to do this mining because they can go like a rat and, cut out the earth and drag it. 15 boys died in the mine because of flooding. Now you kindly see this. This, since it's a judgment passed, therefore I thought I should mention it to all of you, maybe of some interest. We passed an order banning mining in Meghalaya. Second order we passed was the government to frame a scientific, regulatory, environmental friendly policy for the purposes of carrying on mining. Thirdly, we prohibited any kind of activity because there was 23 million tons of coal already extracted and lying on the roads, which caused, because of mining, because of water seepage, and it caused total acidity and black color of the rivers flowing. Then we permitted the transfer of that coal so the economy of the state does not come to a halt. We permitted the transportation of the coal, but prohibited mining till the time all measures were taken and transportation had to be carried out in totally environmental laid down norms as per the mining policy declared. So you can see the contrast that is brought before you. It is so many thousands of workers will die of hunger if you stop. So many commercial loss will be caused to the state if you stop. But then you have to take a call. Do you want your water to be clean? Do you want your next generation to live properly or not? So therefore you call it a day. Second thing which I want to bring to your kind notice is about a case you can imagine. There was a beautiful hill in Shimla, Himachal Pradesh of India. It had trees which were 200 years, 50 to 200 years old, 570 trees chopped off one night. Now what do you do to them? It was a builder buying for the purposes of constructing the multi-storied buildings in Shimla so that he can make good money out of it. He cut out 475 trees of this age overnight. Now we applied all the three principles. We applied precautionary principle in the sense we asked the forest department, and there is a specialized tree habilitation department of Government of India, to ensure them that if they can reconstruct the stems and ensure that the trees can come up again, the one whose stems were still there. Second, we asked him to plant 4,000 trees in the same area where he had taken out those trees. Then we imposed upon him 31 and 20 on the builder, so 50 lakhs, you can say, environmental compensation on them. Now you can't do, these are the things you can't remedy, you can only correct them to a limited extent. Now it is total insensitivity of the person that he wants to make money, and therefore he should chop off 500 trees whether they are needed or not. So these are the few environmental issues we are dealing at a very high scale, and we are trying to say, and oil spilling I was totally impressed by, and I'm thankful to him to give that guidance to us. We have a case where ship was not proper. It was given a certificate to sail. It carried tons and tons of coal, came to Indian high tide waters. It got sunk. Oil leak was there. That ship is there till today. Question is, what should you do? Does another country have a right? Because dismantling a ship is going to cost you millions. Easier way is go to some other country's territory, particularly developing country territory, put it there, leave it for God's sake. This is what I think we need, and I'm thankful to the professor for at least throwing some light on it, how to handle these problems. Thank you, ladies and gentlemen.
A couple of words, follow up. In our civil code, we have an article. We have an article in our civil code that if the activities of some technical site create danger for humans, in this case, it's possible to go to court and ask to stop such activities. On the other hand, if it's impossible not to have such activities, well, if this is an enterprise, the only one in the city, and it's necessary for tens of thousands of people have jobs, maybe the product is necessary for the whole world or for the country, and that's why we have this problem. What is to be done in order to continue such activities? On the other hand, to put losses to the minimum. The problem is there. There could be different solutions nationally and internationally, also making international suggestions. Thank you. I wanted to comment on your presentation regarding civil liability and financial protection, regarding protection of seas and rivers from floods. Last year I told about us, Ministry of Natural Resources, we outlined the draft law, law number 887 about continental coast and internal waters, and about the organizations must have financial backing, maybe bank guarantees, maybe liability insurance, or maybe creation of some foundation at the national level. In the Russian Federation, we have the principles that are reflected in London Convention regarding oil spills, and this year I must say that in implementation of this law, we not this year, but in 2014, we had two documents, 1188 and 1189, regarding the Ministry of Natural Resources, asking other agencies to provide the powers to the cabinet to establish the order of stopping oil spills just on the land, and also the methodology of financial backing calculations regarding prevention of damage to the environment and the third parties and animal world, and Directive 1189 also established the procedure of prevention of sea pollution, and that directive that provided special powers to our ministry. We also outlined the methodology and had the special order, and now this methodology is to be registered by the Ministry of Justice. I just wanted to inform you. Thank you so much for what you said. It shows that your ministry is taking care of our country following the international obligations. We can only welcome such an effort of your ministry. Thank you so much, because everybody is usually reprimanding us, but
Planet seems to be ringing the alarm bells. We are having rising sea levels, earthquakes, floods, all kinds of disasters. But listening to the three of you, there's no question, all three or four of you perhaps, are for sustainable development. Do you think we are doing enough for the preservation of the planet's environment, or are we overreacting to this whole, overreacting to the alarm bells? Do you think we are doing enough, or do you think we need to do much more in the context of the consumption of the planet's resources?
The more the better. Still, I think, and I'm convinced, that what we have even now is quite enough if we use it reasonably and properly.
Mr. Coker, please.
So, in other words, there is no immediate danger to the client, as perhaps what Al Gore perhaps said in his book. He says it's tomorrow morning we are not assured of the planet's environment.
Well, let's wait until tomorrow and then we'll decide this question.
Want to add?
I would like to add at least two things. There are so many good issues, but the first thing is that when I studied biodiversity law, I noticed one important thing, that when we're talking about nature and its biodiversity, then we easily think that okay, nature is something outside human beings and it is protection of species, perhaps ecosystems. But then you soon understand that we are actually part of ecosystems.
Very much so.
Yes. And if I return to original question, that's why environmental law is so important. And the second topic, actually there was already mentioned Al Gore, and I'm actually part of Finnish climate panel, member of it, and climate change is the issue where we still need international convention, but also work in national level. We all must do our part, and we need new legislation. And we also have many other areas where we could make it better, and we need a smarter regulation than we used to have. So work continues still, and we need all nations. It's not enough that what Russia, Finland, India, Bangladesh, China perhaps do. We need all nations to protect this planet.
Ну что ж, я могу только присоединиться к тому, что вы сказали.
Well, I can only join what you said, and that's really so. And the more governments are going to be involved in such universal international agreements, the better is for the humanity. Thank you so much. Are there any additions? Maybe people have questions in the room. While you're thinking, I would like to say, well, first of all, thank you, dear speakers. Thank you, the audience. I can see a lot of our friends. I can see people who just came here. I would like to thank International Union of Lawyers. I am grateful to Federal Anti-Monopoly Service. I am grateful to my colleagues, interpreters. And today we are spending this night and we are comparing environmental roundtable of 2014 and this one. We talked about trans-border water sites, more than 260 in the world, that touch upon the interests of more than 3 billion people. Today we are talking about environmental protection of the whole world, of the globe, and that's why when we were getting ready for the roundtable, Mr. Kumar wrote to me, it could be great for our roundtable to outline some kind of final resolution, and that's why we wrote that we supported that, and maybe we'll consolidate everything that we mentioned today. We'll send it to you if you don't mind, and in this case, apart from the resolution of our forum, we'll also send our own document to the September session of the United Nations. Why not? We should do it. No questions? No more questions? Thank you so much.